judgment in the matter of Department for Business and Trade against the information.
Lord Sales will explain the Court's judgment.
This case is about the operation of the Freedom of Information Act 2000, which I will call FOIA. Under FOIA, a person can request a public authority to disclose information held by it. The public authority has a duty to say whether it holds such information, and if it does hold it, it has a duty to disclose it. But both these duties are subject to certain defences designed to balance the public interest in maintaining the confidentiality of information against the public interest in release of the information. FOIA sets out an elaborate regime of exemptions from the disclosure duties. Some exemptions are absolute. If they apply, that is an end of the matter. There is no duty to disclose. Some exemptions are qualified. If a qualified exemption applies, it triggers a balancing exercise. Under that exercise, the duty to disclose will be defeated if the public interest in maintaining the confidentiality of the information outweighs the public interest in its disclosure. This case is concerned with how that balancing exercise should be performed. The qualified exemptions are set out in detailed statutory provisions. For example, there is a qualified exemption for information relating to the conduct of the UK's international relations. Another qualified exemption is for information relating to the formation of government policy. There are many more. Each qualified exemption reflects a specific aspect of the public interest. Many of them overlap with each other. The balancing test arises under Section 2.2 of FOIA. This provides that information covered by one of the statutory provisions which sets out a qualified exemption can be withheld only if, and I quote, in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosure of the information, end quote. The public interest in disclosure of the information is a concept which covers all aspects of the public interest which point in favour of disclosure. So on that side of the balance, a cumulative approach applies. The question which arises on this appeal is about how the public interest in favour of keeping the information on the other side of the balance, confidential, should be addressed. It often happens that an item of information falls within the scope of two or more qualified exemptions. An item of information may relate to the conduct of the UK's international relations and also relate to the formulation of government policy and so on. An example of this happening is when the government has been working out how to negotiate trade deals with other countries. When that happens, to assess the public interest in keeping the information confidential, which has to be weighed in the balancing exercise under Section 2.2, do you add together all the aspects of the public interest covered by all the applicable qualified exemptions and put that cumulative amount in the balancing scales? Or instead, because one applies each qualified exemption one by one according to its own terms, do you just take the aspect of the public interest reflected in that exemption and put that individual amount in the balancing scales? If you do that, the scales will tend to come down more often in favour of disclosure, and vice versa. I will call the first approach the cumulative approach, and the second the independent approach. In 2017, Mr Montague, a journalist, made a FOIA request to the Department for Business and Trade for information about the trade working groups working on post-Brexit trade deals. The department withheld information relying on the international relations and formulation of government policy qualified exemptions. Mr Montague complained to the Information Commissioner. The Commissioner upheld the department's decision. Mr Montague appealed to the first-tier tribunal, which itself raised the issue for the first time of whether the cumulative approach or independent approach is correct. It adopted the cumulative approach and dismissed the relevant part of Mr Montague's appeal. Mr Montague appealed to the upper tribunal. This time, the Information Commissioner joined in on his side to argue that the independent approach is correct. The upper tribunal accepted that submission and so allowed his appeal. The department appealed to the Court of Appeal. The Court of Appeal held that the cumulative approach is correct and allowed the appeal. The Information Commissioner now brings this appeal to the Supreme Court to submit that the cumulative approach is wrong and that the independent approach is correct. By a majority, the Supreme Court dismisses the appeal. It holds that the cumulative approach is correct as a matter of the proper interpretation of Section 2.2. Interpreting that provision, the Court reasons that since Section 2.2 is concerned with the public interest in maintaining the exemption of the information from disclosure, the natural inference is that it permits the decision-maker to weigh the aggregated aspects of the public interest reflected in the different applicable qualified exemptions. Since all aspects of the public interest pointing in favour of disclosure are added together for the balancing exercise under Section 2.2, it is natural to infer that all aspects of the public interest pointing in favour of maintaining the confidentiality of the information should be added together as well. Only that way can an accurate assessment of the public interest be made according to the balancing test, which is what the statute is concerned to achieve. Moreover, Parliament has itself identified the aspects of the public interest which are reflected in the qualified exemption provisions in FOIA, so there is particularly good reason to bring them all into account if they have a bearing on the public interest balance. In context, the relevant wording in Section 2.2, which speaks of the public interest in maintaining the exemption, is naturally to be read as referring to the public interest in maintaining the exemption of the information from disclosure, rather than as referring only to enforcing a particular statutory provision which sets out a qualified exemption. Also, Section 2.2 refers to the balance taking account of all the circumstances, and if two or more qualified exemptions apply in relation to the same item of information, those are relevant circumstances and so should be taken into account according to the statutory test. For these reasons, the Information Commissioner's appeal is dismissed and the decision of the Court of Appeal is affirmed.